beseech you to grant us leave to have those documents circulated among the senators. We also have documents that are mentioned in the various witness affidavits, but which unfortunately were not reproduced when the volumes were being made. By name, we have a staff redeployment memo dated 10th January 2025, an internal memo of the county government of Kericho. We have certain printouts of M-Pesa statements that are referred to in the affidavit of Erick Koech. We have the letter dated 21st August 2025 with regard to the report of the ad hoc committee on Kazi Mtaani, which, Mr. Speaker, you have alluded to. It is referred to in the affidavit of the motion mover. We have certain RTGS payment extracts that are referred to in the affidavit of Albert Koech. We have the termination letter of Enoch Koech that is referred to in the affidavit of Erick Koech. We have an invitation for a meeting with the Joint County Assembly Committee on Water and Sanitation and Environment and Forestry and Natural Resources and Minutes. The committee report of that committee, my apologies, the report of that committee is before this House, but only the invitation letter that was omitted in the course of the photocopying. Then we have bundles of invitation letters dated 18th July 2025 to appear before the ad hoc committee of the County Assembly of Kericho on fictitious payments. Again, the report of that committee is already before this House. So the only documents that were omitted were the invitation letters, which we seek that you permit to be presented to this House so that we have a complete record. Then finally, Mr. Speaker, we have certain photographs and an attendant certificate of electronic evidence. The photographs are referred to in the affidavit of Kiprotich Rogoni, and the certificate of electronic evidence is also in that affidavit, but unfortunately, in the course of mass production of the documents, they were omitted. Those documents, Mr. Speaker, we beseech you to allow the senators to have access to them so that we can have a comprehensive view of the situation. The other documents are the ones, as I alluded to earlier, relating to the answer to the PO. I will suspend dealing with those ones as directed by the Speaker, and I'll deal with them as and when that PO becomes a relevant issue before this House. My learned colleague should draw my attention to something so that we don't waste time. I'll ask him just to present it to the Senate right away so that the Senate can make a decision.
Thank you, Mr. Speaker, sir. For record purposes, my name is Elias Mutuma. I just wanted to confirm that the documents that my learned senior has alluded to have already been supplied to Council for the Governor through email yesterday, and physical copies were delivered this morning. Thank you.
Council for the Governor, do you have any objections to that request?
Mr. Speaker, sir, and honorable senators, we very strongly object. We very strongly object. It is true that we were Mr. Speaker, sir, we strongly object to the attempt to introduce new evidence at this point. It is true that this morning, as we were waiting to walk in here, we were served with the documents referred to by my colleague. Mr. Speaker, sir, the first point of our objection is that we will not have had an opportunity to have looked at them and to prepare ourselves to respond to them, considering that today is scheduled for hearing. The second objection, Mr. Speaker, sir, is that you already gave a timetable within which the filings were to be done, and we all struggled to file within that time, including ourselves, who had also equally voluminous documents. So the mere contention that it was voluminous is not good enough a reason. The third objection we have, Mr. Speaker, sir, is that they were not part of the documents that were used during the proceedings at the County Assembly. And for purposes of that point, Mr. Speaker, sir, I wish to make reference to your standing orders, the standing orders for this, for the Senate, particularly the standing order number 20. The standing order is to this effect. In presenting its evidence, the Assembly shall not introduce new evidence that was not part of the allegations against the governor in the County Assembly as forwarded by the Speaker. Mr. Speaker, sir, it is our contention that that standing order clearly prohibits the introduction of this new evidence. It is also our argument that if that evidence had been brought to the Assembly, there is also the possibility that the Assembly could have voted differently. And so, Mr. Speaker, sir, we take objection to the introduction of the new evidence, and we insist that the matter proceeds as per the documents that were filed within the timelines that you had given. Mr. Speaker, sir, I would like my colleague, Mr. Wanyama, to make supplementary submissions on the issue.
Mr. Speaker, sir, the Honorable Senators, just an additional remark. If you look at paragraph 16 of the motion and the entire motion, there is certainly evidence which the mover of the motion wanted to adduce before the County Assembly. At paragraph 16 of the motion, the mover of the motion specifically said on the floor that that evidence will be sought after asking the House to issue summons. And throughout the motion, you will see that then there is no evidence. An allegation has been made and no attaching evidence has been adduced. So that was the evidence which was submitted before the County Assembly and a decision made on them. So in accordance with your rules, and we strongly object to this, the County Assembly cannot introduce new evidence, even if it was mentioned in the pleadings before the County Assembly. It cannot introduce that new evidence before this House at this stage for only one reason. It's extremely prejudicial to the governor. And secondly, the governor has not had the opportunity to prepare on this evidence. But more importantly, this evidence requires comment from the governor. And therefore, the right to fair hearing will be severely breached if this evidence, which the County Assembly is now doing a patchwork, is introduced at this stage. And lastly, it will contravene your express, clear, and unequivocal rules that no new evidence shall be introduced on the Senate if they are not part of the evidence submitted against the governor in the County Assembly. Thank you.
Mr. Speaker, may I have a brief right of reply?
Council, let me just make a ruling on this matter. We make progress.
Thank you, Mr. Speaker.
We've had your position. We've had the governor's position. Now, if I had counsel for the County Assembly correctly, is that the evidence related to those documents is already in our bundles, the original bundles. These documents were omitted by mistake during the compiling of those bundles. They do not introduce any new evidence as is being submitted by the counsel for the governor. And therefore, pursuant to Rule 30 of the Rules of Procedure, I will allow those documents.
Preliminary objection, and the same was part of the filings we did within the timeline you gave us. The nature of our preliminary objection, Mr. Speaker, sir, is to contend that there was no voting that took place, and therefore it implicates the requirement, number one, that voting must have been done at the Assembly, and number two, that a 2/3 threshold should have been achieved. It is our contention that the approach adopted by the Speaker in the County Assembly, the documents filed, including the audit of the logs of the process, will show that indeed there was no voting system. Mr. Speaker, sir, I pray that you allow us to raise that preliminary objection to the effect that indeed no voting took place and that 2/3 was not achieved, and therefore your jurisdiction has not been triggered as a Senate.
So, Council for Governor, you have 15 minutes to raise your appeal. Council for the County Assembly, you'll have 15 minutes to respond, and thereafter the Senate will make a determination on the matter.
Mr. Speaker, sir, the issues we raise in our preliminary objection are that we will start, first of all, Mr. Speaker, sir, we will invite your attention to the contents of an Annex 4A from the Assembly, which provides an audit of the login processes and details of how the voting went on. And Mr. Speaker, sir, that is contained in the affidavit by the IT expert at page 79 to 85, and also in the affidavit sworn by the clerk, page 95 to 93. And Mr. Speaker, sir, the IT expert says particularly at paragraph it is volume 2. Volume 2.
What is your issue, Senator for Nairobi?
Volume 2 of the County
Council
Assembly.
for Governor,
Bundle.
just hold and pause the time for the Governor, please. Yes, Senator Sifuna.
No, Speaker, we've been through this process many times, and these are experienced lawyers. Part of the thing they should do before they start is to introduce to the Senate their documents. You can't just refer to documents, and we have volumes upon volumes here. I would expect that Council for the Governor start by telling us what his documents look like, and then we can be able to go together. Other than that, you're just speaking to yourself. With respect, Council.
Council for Governor, kindly be guided accordingly.
My apologies, Honorable Senators. I'm referring to volume 2 of the County Assembly bundle, and I will be juxtaposing that with bundle Annex 4A, also from the County Assembly bundle. Mr. Speaker, sir, our preliminary objection, the first point I wish to address is what has been referred to by the IT expert, and that testimony, his affidavit is at page 79 to page 89. And at page, particularly page 81, paragraph 10, 11, and 12, he indicates that they have been using certain software for purposes of payments, budgeting, meetings, and so on and so forth. Then he says in October 2024, an enactment was made of Standing Order number 77, and attendant to the enactment of that section, they then developed a system for voting by upgrading what they already had for purposes of implementation of that standing order. Then he proceeds at paragraph 23, 30, and 31 to say that system is accurate, verifiable, secure, user-specific, and friendly. And Mr. Speaker, sir, that's where our preliminary objection lies. We would like to say, first of all, if it were a specific, if it was tailored to meet the intention of that standing order number 70, the standing order number 70, standing order number 77A requires that in the event an MCA chooses not to vote, then it must be deemed to have abstained. Mr. Speaker, sir, when we look at volume 1 of the Governor's bundle at page 98 to 101, if we could look at that. The Governor's bundle, page 98 to 101 to 106. It is the bundle is pink in color. It will be noted that if indeed it was tailored to meet the intentions of Standing Order number 77, then it should also have complied with the detail of 77.8, which says that any MCA who has not voted should be reflected as having abstained. You will notice at page 98 that The votes reflected in that report says 33 voted and there was 0 abstain. However, when you juxtapose that, if we could go again to the volume 2 of the Assembly's bundle, you will find an affidavit by the clerk of the county assembly at page 90 to 93, and particularly at page 90, at paragraph 17 at page 93, the clerk is very specific that there were 47 MCS in the assembly on that date. Now, our case is that the 18 MCS did not vote at all, and we have produced those affidavits. And those affidavits of the 18 MCS I will provide in a minute. But let me just make this first point I was making, being that if the system that they say was tailored to meet the intention of standing order number 77, then 77.8 requiring that it should reflect abstention, then should have reflected 18 MCS abstained, or in the alternative, if it were to be the case which we contest, if it were to be the case that 33 voted, then it should have reflected that 14 of them abstained. And so that's our first attack on that pretense that there was any voting that happened. It is our contention that just a piece of paper was prepared. The second argument we make is that 18 MCS did not vote, and the maximum number of votes that that system should have reflected should have been 29 votes. And the affidavits that we have produced for purposes of supporting that proposition, Mr. Speaker, sir, are at page 117 to 120 of the governor's bundle. That is an MCA called Kiptagan. Then there is an MCA called Kibet Bozuben at page 121 to 122. Then there is Amos at page 125 to 127. Then there is Edna and Martin at page 128 to 131. Then there is an MCA whose nickname is Broker at page 132 to 134. Then there is an MCA called Gabriela at page 135 to 1. I was just struggling with the 15 minutes I was given, Honorable Senators. Then there is an affidavit sworn by one Gabriela, Honorable Gabriela at page 135 to 137, and an affidavit sworn by all the 18 jointly at page 113 to 116. In the same set of the documents, we have shown how they have already reported to the DCI for purposes of investigation of the impersonation of their votes. Mr. Speaker, sir, may I indicate that all the 18 MCAs are our witnesses, and we intend to call all of them, probably 17 or the 18. And Mr. Speaker, sir, and Honorable Senators, it is our contention that indeed, to the extent to which 18 of them did not vote, the representation that 33 MCAs voted is inaccurate. It should have been